Hear ye, hear ye, hear ye. The Colorado Court of Appeals is now in session.
Thank you. Please be seated. Good afternoon. Welcome to Division 4 of the Colorado Court of Appeals. We have on our 1:30 docket today 2 cases. Introductions first. I'm Bob Hawthorne. I'll be presiding over the proceedings this afternoon. And to my right is Chief Judge Alan Loeb. To my left is Judge Michael Berger. We will be the panel members who will ultimately render an opinion in these 2 cases that are on our docket this afternoon. A few things before we get started. Have counsel had an opportunity to read our practice and protocol handout, and do you have any questions about any of that? I think both of you are probably experienced appellate counsel. I've seen you here before, I believe. I'll remind you that we are now live streaming all of our oral arguments, so if there's anything confidential or sensitive in the cases, please be sure to be aware of that and act accordingly. As far as the folks in the gallery, if you have a cell phone or any other device with you that might go off during the proceedings, if you would please turn those off so they won't interfere with counsel's arguments today. And the timer is self-monitoring, of course, and appellant, you have the opportunity to reserve time for rebuttal if you wish to do so. If there are no further questions, we're ready to proceed on the first case this afternoon, and that's People versus Gerber, 2016 CA 909.
Malika Magner, attorney registration number 27149. Good afternoon. Representing defendant appellate John Gerber, and I would like to reserve 5 minutes for rebuttal. May it please the court. The issue of the sufficiency of the evidence for Mr. Gerber's conviction of first-degree kidnapping was not preserved, but he urges this court to accept the conclusion of People v. McCoy that the due process clause protects a defendant in a criminal case against conviction, except upon proof beyond a reasonable doubt of every element of the crime, which the people did not do here. The facts in this case are undisputed. The only question is whether the facts suffice to support a conviction for both first-degree kidnapping and aggravated robbery. They do not. Rather, they support a conviction for aggravated robbery only. At about sometime after 7 a.m. at an old Chicago restaurant in Grand Junction, the manager heard the doorbell ring at the back door, and he went to the back door and opened the door to see 2 masked men, one of whom was holding a gun. The men directed him to take them to his office, which was about 15 to 20 feet away from the back door. And for a visualization, a Ford pickup truck is about 17 and a half feet long, so it was somewhat shorter than a pickup truck or somewhat longer than the pickup truck's length distance. When the 3 men got to the safe, the men with the masks ordered the manager to open the safe. He did so. There was very little, if no conversation. The men took the money, put it in a bag, and directed the manager to the walk-in refrigerator where they loosely handcuffed him. And a short time later, he was able to release himself when he heard that there was no more noise and assumed that the robbers had left. The police were dispatched about at 7:15 a.m. The evidence of the manager was that he was in the office for no more than a couple of minutes. So the entire event was a very short in duration. The crime of aggravated robbery is the knowing taking of anything of value from the person or presence of another by the use of force, threats, or intimidation. It becomes aggravated robbery as charged here when that robbery is committed by one possessing what reasonably is believed to be a deadly weapon. That is the crime which the people proved here. What the people did not prove is the separate and more severe crime of first-degree kidnapping. Aggravated robbery is a Class 3 felony. First-degree kidnapping is a second-degree felony. The penalties are twice as severe for the second-degree felony as they are for the third-degree felony. The crime of first-degree kidnapping, as charged here, is robbery, which is a person who knowingly takes, so now I want to move on to my first-degree kidnapping. So first-degree kidnapping is when someone imprisons or forcibly secretes any person with the intent thereby to force the victim or any other person to make any concession or give up anything of value in order to secure the release of a person.
Does the fact that the defendant put the manager in the cooler have any bearing on your argument?
It does not, because first-degree kidnapping requires that the intent to force a concession to secure the release. At that point, the concession, if there was one, was already made because he had already given the access to the safe and the robbers had already taken the money. So in People v. Bridges in 1980, the Colorado Supreme Court grappled with distinguishing between robbery and first-degree kidnapping and expressed its concern that a kidnapping charge can be used to obtain a sentence not otherwise available to the people. And the court was very clear that proof of an intent to force the giving up of a thing of value is only sufficient to support a conviction for robbery. So the question becomes, what makes a robbery a kidnapping where the underlying crime is the robbery? Because if I am walking down the street and somebody comes up to me and holds a gun to me and says, "Give me your money," at that point, according to the people's argument, I am imprisoned because I am not free to leave. I am no longer at liberty. So during the time that I am nervously fumbling through my purse, trying to go into my wallet to get my money, does that suffice to be a first-degree kidnapping?
So under the applicable law in Colorado, what is the relevance in this case of the movement element, if you will?
Well, Your Honor, that's the tricky question, because there are two subsections that are pertinent here to the first-degree kidnapping statute, and the one is forcibly moves or carries a person from one place to another. Those are the cases that have all been interpreted by the courts. All of the case law deals with that subsection of the first-degree kidnapping statute, forcibly carries a person from a place to another. So all of the analyses address movement. However, Mr. Gerber was not charged under that subsection of the statute. He was charged with the subsection of the statute, subsection C, which is forcibly imprisons or secretes. But I think that the analysis of the movement, so the movement analysis is basically that it becomes first-degree kidnapping if the movement is not incidental to the underlying crime, and that the movement substantially increases the risk of harm to the defendant. So the case is People v. Swanson, where the hitchhikers hold the gun to the driver's head and ask to be taken to a wooded area. That substantially increases the risk of harm to the victim.
Is it and or? In other words, if the people establish either one of those. Is that enough, or does this have to be both?
Imprisons or secretes?
Yeah, no, risk of harm. As I understand, the Attorney General's arguing both prongs, that there was an increased risk of harm because presumably passersby could see the manager at the door when he opened the door, but then they forced him into the office where no one could see him, so that increased the risk of harm. And then you gave a second condition that I think you said, and.
It's not merely incidental to
Right.
the,
So is that disjunctive or conjunctive?
well, basically what the courts have said is that we look at circumstantial evidence to ascertain what is the intent of the perpetrator. Is it to commit the underlying crime only, or is it to commit the crime of kidnapping in addition to the underlying crime? So what the courts look at is both. So, but I would like to take issue with the people's characterization that the risk of harm was increased because the safe was always going to be inside. It's not like Swanson where the hitchhikers forced the driver to take them to a more deserted area, or Morgan where he had the victims go from their apartment to a deserted construction site. No, the crime was always intended to be inside the restaurant where the safe was located.
But suppose your client accosted the manager. The manager is outside the restaurant.
He's not outside the
No, I know,
restaurant.
but I'm giving you a hypothetical. The manager is outside the restaurant. The robber forces him into the restaurant, and there's lots of passersby around, so people could see what is going on outside. They can't see what's going on inside. Wouldn't that hypothetical support both convictions for first-degree kidnapping and aggravated robbery?
Well, the court in People v. Bridges addressed what are those factors? What factors do give us an understanding of the intent of the defendant? And those are the time of the detention, the distance of the movement, any changed environmental factors, whether the commission of the underlying crime and the movement were simultaneous, and the consistency of the defendant's actions with an intent to kidnap. So it's not merely movement. So in this case, the crime was of extremely short duration, approximately 2 minutes. The distance that the victim was moved was about the length of a pickup truck. Essentially, what is clear here is that the crime of aggravated robbery was the crime that was intended, and any movement was incidental to the crime. I think it's appropriate because all of the cases deal with the asportation subsection versus the imprison or secrete subsection under which Mr. Gerber was convicted, to then, instead of look at movement, to look at detention. So what was the length of the detention? The people argue that the crime of kidnapping commenced when the manager came to the door and saw the gun. And then the crime of the kidnapping continued until he was in the safe. And then it appears that the people are arguing that then the crime of kidnapping finished, and then the crime of aggravated robbery commenced, because the aggravated robbery was the taking of a thing of value by threats, force, or intimidation, and the use of a deadly weapon. So, but what really happened was Mr. Gerber and his confederate were intending to commit the crime of aggravated robbery. The manager never came outside the restaurant. He was at the doorway. The robbers came in, went a very short distance. They never asked him, they never said to him, unlike in some of the other cases, they never said, hey, if you just cooperate and give us everything, we'll release you. So did he make a concession? I would argue that in every case where there is the use of force, threats, or intimidation, when somebody gives over their wallet, when they're on a street, they are making a concession because they don't want to be shot. So the legislature created two separate crimes with very different penalties. The penalty for the Class 2 felony is double that.
You're
So
down
they
to about 2 minutes. I'll just remind you, you
Thank you.
mentioned 5 minutes. but-
So they did not intend that every robbery also be subject to the enhanced penalties of a first-degree kidnapping. The people have conceded about the first-degree burglary sentence, that needs to be resentenced, and also because the crimes all arose from a single event and were supported by identical crimes, then Mr. Gerber should have been sentenced concurrently and not
I don't
consecutively.
understand. I understand that the crimes occurred in the same criminal episode, but I don't understand your argument that the evidence supporting each of the convictions was identical. Can you elucidate on that a little bit?
So the facts were, Mr. Gerber and his confederate intended to go in and take the money from the safe and did so. Those are the facts.
The burglary was complete the minute he entered the premises, right? There's no question they intended to rob the store. So that crime was complete at that moment when he entered the premises. The robbery had not yet occurred. How is the evidence identical?
The evidence is identical in the same way that it is identical in O'Shaughnessy, where separate crimes ended up being charged, but out of the same set of facts. So this is similar to O'Shaughnessy, and because the evidence is identical, the crime should be concurrent. So I will save my remaining time for rebuttal. Thank you.
May it please the court. My name is Jacob Lofgren, registration number 40904, and I represent the appellee, the people of the state of Colorado. The people respectfully request that this court affirm the district court's judgment of conviction because the evidence here was sufficient to sustain a conviction for first-degree kidnapping. The key case here, and I think I agree with defense counsel on this, is Bridges. It's the only major case on point, and every case that is out there addressing the first-degree kidnapping statute addresses only the movement provision. There are no cases that address the imprisonment, forcibly secrete subsection that is at issue in this case.
Is that true of the Owens case as well?
Yes, that's true of Owens, it's true of Bridges, and it's true of the three other cases that I string cite in my brief. All of them deal with the movement provision. We have nothing that directly tells us how to interpret imprisonment, how to interpret forcibly secretes. And the reason I pause to point that out is this is a plain error analysis in this case. The defendant did not preserve a sufficiency objection. He never put the court on notice that he was concerned that the elements could not be met in this case because of the imprisonment provision.
Well, would you acknowledge that there is, at a minimum, a split on our court about that issue?
That's absolutely true. In Rediger, when the Supreme Court addressed that split, they chose not to answer that question today. But I think, particularly in light of the facts and circumstances of this case where defense counsel specifically said, I'm not raising a sufficiency challenge to the first-degree kidnapping, only to another count, we have to look at, was it so obvious here that the district court should have said on its own that these elements cannot be met? And I don't think there's any way it could have been obvious to the district court because there's no cases on point. The only cases that we have to work from here address a separate subsection, and while they're somewhat helpful in analyzing the statute, they certainly don't give a concrete answer that the district court could have relied on to step in on its own and say there's no way the evidence can be sufficient here. But I do want to talk a little bit about Bridges, since it is the key case, the only case that we can really apply here from the Supreme Court. In Bridges, the court did say that the movement has to be enough to force the concession, and it cannot simply be incidental to the crime. And Bridges listed a number of factors that can be used to assess that movement, including the duration, the change in environmental factors, those kind of things. And in this case, both the movement and the detention are enough to support the kidnapping conviction. I think I agree with defense counsel's recitation of the facts, but the two things I would add to it are this. At the door, when the defendant knocks on it or rings the doorbell and the victim opens it, he says, "Take me to the office," with a gun in the victim's face. A command, an order. The victim follows that command, that order, moves from the open door to the inside of the building where there is no one else. It's locked. It's just him and his assailants. Goes 20 feet down a hallway to a back room office where no one can see him. There is no one else in the building to help him. And at that point, the defendants continue to point the gun at him and say, "Open the safe." They're demanding a concession. If they don't get that concession, the victim has no idea what's going to happen to him. Presumably, he's not going to escape unharmed.
But it wasn't all that necessary to do the robbery? In other words, if you're going to rob the store, presumably the money's in the safe, the store's not even open at that point, don't you have to bring the manager over to the safe to get the money? And if so, isn't that part and parcel of the aggravated robbery as opposed to the separate crime of kidnapping?
I think it's a close call, certainly. I don't think this is an obvious case where 100% that there's separate acts. But I think there is enough here to say it is not just incidental. I mean, incidental would be the situation you have in Owens, where two people are inside of the fast food restaurant already, and the defendant says, "Give me all your money," or "Give me the money in the register or in the safe." And that is the only act that happens. Here, the movement's way more than that. You move from the outside, from the door, to the inside of the building, to a back office, where all of the actions related to the robbery take place.
Well, the only people who move from the outside are the perpetrators. The manager was inside the whole time, wasn't he?
I think that's arguable. I think when he opens the door, he's making himself visible to the outside. People passing by, driving down the road, walking by on the sidewalk could see what was happening at that door.
Is there any evidence of that in the record?
That they could?
Yeah,
No. No one specifically testified that that's the case.
well, but wouldn't you have to have that kind of testimony to be able to make that a factor as you're arguing? How do we know that?
That people could see. I mean, it's an open door. I think it's a reasonable presumption from the record that when he opened the door, he could be seen from the outside. The other thing I think is critical here to remember that makes a difference in the forced concession is that the safe was locked. The only way the defendants were going to get access to that safe is by the victim complying with their commands. That's the concession here. That's the key fact that gets us to the kidnapping conviction. And that concession only happened, again, after he's marched from the back door, down the hallway, into a closed, a small back office where no one could see him.
So if the money's sitting on the counter, it's just a robbery, but if the money's in a locked safe, then it's a kidnapping and a robbery?
That's certainly going to be a closer case because proving the concession would be a lot different. Here, the concession is the act of kneeling down, unlocking the safe, taking the money out, and handing it to the defendants. If someone just comes in and you have a pile of 50s on the counter and they say, "Give me those 50s," it's going to be a closer call on whether you can get a kidnapping and a robbery. I think that's true. In terms of defense counsel's argument that I'm suggesting the kidnapping is the entire act of movement down the hallway, the movement is a component of it, but what I am arguing in this case, particularly under subsection C and the imprisonment, is that the imprisonment occurred in the back office. That's where the imprisonment occurred, not the act of marching down the hallway. That might be enough under the movement subsection, but under subsection C, imprisonment, we need to look at what happened in that room. Small backroom office, could not be seen, held at gunpoint, and could not move. If we look at it similar to a custody situation, we would certainly say that someone held at gunpoint in a small room where they couldn't be seen was not feeling free to leave.
But you're not relying on the fact that the defendant put the manager in the cooler?
I am not. And I think the reason I am not doing that is based on Bridges, as much as we can apply it here, the concession has to occur, can't occur prior to the imprisonment. I think that's a fair reading of Bridges. I think that's a fair reading of the other cases that kind of apply Bridges. And here, the act of imprisoning in the cooler occurred after any concession occurred. The other thing I did just want to briefly address is Owens. I think Owens is the closest factual case we have to what occurred here. It is a restaurant robbery, and to the extent it can be applied here, despite the fact that it applies a separate subsection, the different facts that distinguish this case from Owens, first, environmental changes. There were none in Owens. Everything occurred inside the restaurant. Here, started at the door, moved inside. I think that's a key difference. The other big difference is that the movement, the physical distance, and into a back room was enough to say they were trying to secrete him, they were trying to hide their acts. That wasn't necessarily present in Owens. So I don't think Owens necessarily dictates the outcome of this case.
They weren't really trying to hide their acts, they're just trying to get to the money.
Both, I think. I don't know that it was that necessarily their decision-making in moving from the inside to the outside related to hiding their acts, but it certainly was an outcome of that decision. They could have just knocked on or rung the doorbell, waited for him to open it, and said, "Give us your wallet." That
But
wouldn't
they
have,
wanted the money from the store, they didn't want his wallet.
right,
That wasn't the crime.
right. I agree, but I think that certainly the act of moving to the inside resulted in hiding their acts from public view. I did just want to briefly address the consecutive sentencing component, since defense counsel raised it. I think here we have three clear, separate acts that occurred. The first, an unlawful entry that supported the burglary conviction. The second, the imprisonment in the back office that supported the kidnapping conviction. And the third, the violent taking, the actual act of forcing the victim to remove the items from the safe that supports the robbery conviction. So I think in its discretion, the district court certainly could impose consecutive sentences in this case.
If we vacate the kidnapping conviction, what do we do regarding sentencing?
Well, I think a remand for resentencing has to occur here to begin with, just because the burglary sentence was incorrect. But I think on remand, the district court should have at its discretion the ability to impose a harsher sentence for the remaining convictions, so long as the length of the sentence does not exceed what it currently is. If this court has no further questions, I would ask this court to affirm. Thank you.
Counsel, you have 9 seconds.
9 seconds. In Owens, the court specifically found that there were 3 cases. One restaurant manager was seized and carried when he stepped outside his office, and the record reflects that the first 2 victims were also taken by knife point from the restaurant entrance, where they could be seen by passersby, back into the office. Owens is almost directly on point with the facts of this case. That case found first-degree kidnapping was not proven. Likewise, should be in this case. 9 seconds?
That's it.
Thank you.
No, you actually took a few more than that, but
Thank you.
thank you, counsel, for your arguments. Those arguments will be very helpful to the division in reaching a decision in this case. And the matter will now stand submitted, and then opinion will issue in due course. Thank you very much. Council are excused, and as soon as council have cleared the council table, other council can come forward for the next case on the docket. Good afternoon, council. Next case on the docket is People versus Manjarrez, and that's case number 2017-CA0326. And council, do you have any questions about our protocol or procedures here today? Okay, and I think a few people just walked in. So if you have, I'll repeat what I said before about cell phones. If you have cell phones, please be sure to make sure that they're turned off. And with that, we can proceed with People versus Manjarrez.
Thank you, Your Honor. May it please the court, counsel, Robert Fishman, on behalf of Mr. Manjarrez, is how I've always pronounced it.
Oh, is it? Okay. Excuse me for that.
Position of trust was the only issue really at trial, and it's the only question before this court on appeal. There are 3 distinct legal claims that we raise related to that. And I'd like to start with the third one because I need to clarify the scope of that issue. Really, I need to narrow it from the way it was presented in our brief. We argued in the preservation section of our brief that the court ruled on the admissibility of the what we call flirtation evidence prior to trial and overruled a whole series of objections to the exclusion of the same evidence during the course of trial. And that is all accurate. In the argument section of our brief at page 22, we said the court erred in its pretrial ruling and the error became even more obvious as the trial progressed and the evidence came in. And that's not quite right. The first part of it is not quite right. I don't think actually that the court abused its discretion in its pretrial ruling. And we don't argue that issue really in our brief because the argument at that stage of the case was separate. It went more to the victim's state of mind and perception of the defendant than it did to anything else. As the evidence comes in during the course of the trial and the theme that mother and father trust my client, he's a family friend who has a good relationship with them and their children, and particularly when father is on the stand saying, I allowed my daughter to go to work for this man because he had a healthy relationship with my daughter. I was fine with it and I trusted him. And it's at that point where the analysis of the flirtation evidence just changes 180 degrees from what had been argued prior to trial, because the evidence of flirtation, I don't have to recount the details. It's 2 incidents, and it's the proffer is it's very suggestive, sexually suggestive conduct directed from the child to my client. And the key fact is father is there, is a witness to it. And so that just directly and fundamentally undercuts the testimony that I trusted this man because he had such a healthy, normal relationship with my daughter. And not just that, it undermines his credibility in general, because I think any fair reading of the transcript shows that, not surprisingly, that father was a very antagonistic witness. The DA couldn't control him, the court couldn't control him. The accusations were pointed and flying, and the judge was frustrated, numerous motions for mistrials. It's key evidence. He's, of course, one of the key witnesses in the case. And so the scope is narrower than I presented, but the meat of the argument obviously remains, and that is that the court abused its discretion in excluding this evidence, number one, because of its probative value, obviously, but also because there was really no prejudicial effect on the prosecution's case apart from the fact that it's bad evidence, but that's not the sort of prejudice a court considers. It didn't go to a question, say, of consent. There is no issue of consent here. It's not rape shield evidence. There's no question of that. So the argument is reversal is required for that reason alone. And of course, I'll point out that the prosecution does not argue that the error is harmless. They say confidently, there's no error at all, so we're not going to entertain the possibility of any fallout from this ruling. So on that record, I think reversal is required.
Let me ask you a question, Mr. Fishman, about, I'm trying to understand your argument. You're saying that the trial court abused its discretion in excluding this flirtatious behavior
Right.
evidence because it was relevant to undermine the credibility of the father and his testimony. Is that your argument now?
That is true, and I am arguing that. But the reason, it goes beyond merely credibility. It is because the whole case really turns on position of trust, and the whole theory of prosecution is mom and dad and child trust this guy.
Okay.
Ergo, he is in a position of trust. And why do we trust him? For a whole number of reasons. But I would say, critically, because he has such a healthy, normal relationship with my daughter. That's why I trust him. I've seen them together all the time. They're great. You know, they get along great. He's a friendly guy. She's a friendly girl. They kid around. They're great. They golf together. That's why I trusted him. And the response to that, the cross-examination to that, is, well, what did Mr. Trinidad observe in the hot tub between your daughter and my client? And how can you reconcile that with your testimony that this is such a normal, healthy relationship? That's why you trusted him. That's why he's in a position of trust.
But the testimony was going to be about the victim's actions or flirtatious behavior with the defendant, not the defendant's actions or conduct toward the victim.
Right,
Is
and
that
I
right?
think it's,
And I'm having a difficult time understanding why the victim's conduct toward the defendant would have the effect that you're saying it does. I could probably understand that if it was the defendant's conduct toward the victim, rather than the other way around.
right, the key fact that I agree with Your Honor that typically that's not going to matter, the way the kid acts in the house with, the defendant. It's not going to make any difference to position of trust. The key factor here is father is a witness to that conduct. It is not the conduct per se that relates to the position of trust question. It is the fact that father is aware of it, and despite the knowledge, despite having observed the conduct, he is still on the stand testifying, I trusted this guy because he had such a pleasant, healthy relationship with my daughter. That's why I let her go to work for him. That is why he occupies a position of trust. So it all stems from the child's conduct. As an evidentiary matter, her conduct is implicated clearly, but as an evidentiary matter, the relevance of it and the probity all goes to father's testimony, state of mind, judgment.
Why doesn't it come out just the other way? I mean, if father sees the flirtatious behavior of the daughter, and still then gets up on the stand and said, but I trusted him, why aren't those two, why doesn't it just fortify that, quite frankly? Instead of, I don't see how it makes the position of trust issue different.
Because the position of trust issue is not based on sort of what you typically see in these cases so much, objective facts. You picked her up from the family's house, you took her to your trailer to do a job, and you assaulted her. It turns on almost entirely on the parents' judgment about this man and their trust in him. And I think if the argument were from father, yeah, I saw this behavior and it was really pretty risque. I trusted him anyway, and that's why I let her go to work for him, and that's why he's in a position of trust. You know, I think any good defense lawyer at trial is going to have a field day with that, and you never know what a jury is going to do with a cross-examination based on an admission like that.
Mr. Fishman, before you run out of time,
Yep.
I want to switch gears to the sufficiency.
Yep.
And, I mean, my sense is that absent a couple Colorado Supreme Court decisions, you'd have a pretty good argument based upon the language of the statute that there is insufficient evidence to support the conviction. But we got this little detail of 2 Colorado Supreme Court decisions, and let me read you what I think is the critical passage from Rogo, and I'd like you to tell me why, whether it's right or wrong, we're bound by what the Supreme Court said.
Sure.
They said, rather, a defendant may occupy a position of trust with respect to the victim where an existing relationship or other conduct or circumstance establish that the defendant is entrusted with special access to the child victim.
Well, first, Judge Berger, I agree with you. It's a much easier case based on the statute, and Rogau is a speed bump for us on the argument. But my response to that is, again, you have to look at the evidence. Beyond the evidence we've already talked about, the evidence is undisputed. 2 things, really, that are most important to Rogo, and in particular, this use of the term entrusted. The first is mother testifies, I didn't know whether the defendant was going to be at home when my daughter went to work to clean his house. He could have been out of the country. Didn't matter to me. She's 17 years old. She doesn't need to be supervised. And father said he didn't think that my client had any responsibilities towards his daughter whatsoever in terms of supervising her welfare. So the key question, I think, under Rogo, and we argue it in our opening, in our reply, it's really not responded to by the prosecution. How can you entrust someone with a thing when you have no idea if that thing is going to happen and you don't care whether it happens? And the thing that I'm referring to is the presence of my client in his home while the girl is there working. And I think what kind of highlights the significance of the term entrustment, which is repeated throughout Rogo, is the prosecution's argument on this is he gained special access through this relationship. And I think that's a big difference because you can break into a bedroom window at night and gain special access to the person who's sleeping in there. Entrustment requires some sort of intention, some sort of judgment made on the part of parents. They're reposing trust in the defendant and allowing special access as a result. And in this case, they just really, they don't care. They don't care if he's there. They don't know.
But didn't the defendant ask the victim's father whether it would be okay if the victim did some cleaning?
I don't think so. I think what he said is, you think she'd like to earn some money coming to work for me?
Cleaning
the house. So it's not, will you give me your permission for her to work? He's saying, he thinks she'd like to earn some money cleaning my house. And the father says, I'll ask her. I don't care. I mean, maybe. We'll see. I'll ask her.
But isn't it then just a jury question given the reformulation of the statute by the Supreme Court?
Well, typically, of course, it would be a jury question, but I think when you have undisputed evidence that the parents didn't know he would be there and they didn't care, I don't think it's a fair inference to say they're, quote, entrusting their daughter with this man, because they don't know that they are. And I think 2 hypotheticals, the difference is highlighted by saying, what if they would have said, you can go to work for him, but only if he's at the house while you're there? We lose under Rogo. What if they had said, you can go to work for him, but he can never be at the house? I think those differences go to highlight that it turns on these sort of intentions and mental state really of the parent who's authorizing the conduct. And when you have parents saying, we didn't care about that, I think a jury cannot reasonably conclude otherwise. And with a minute 22, I'd like to reserve my time.
Okay. I'll reserve my question.
Okay.
Good afternoon, Your Honors. Melissa Allen, registration number 23155, on behalf of the people. I'd like to start with the first issue, and then I'll go to the third one, if that's okay. In the defendant's briefs, a lot of the argument assumed that someone in a position of trust has to fall under the two enumerated categories that are listed in the statute. And that, as this court knows, is simply wrong, because the Supreme Court has made clear that those categories are just illustrative, and that the broad definition of position of trust adopted by the legislature is not just limited to those categories. And this case is a good example of something that falls outside of those two categories.
What does special access mean?
Special access means you have the opportunity to have alone time with that person by virtue of your relationship with that person, that victim, and that victim's family. That's the way I read it. That's the way I think that's what the court was saying in Rogo. And the defendant clearly had special access to the victim in this case because he was at his house when she came to clean. And that gave him the opportunity to be alone with her.
So if I hire a housekeeper, I don't know who this person is, but they're recommended to me, and I hire them, I have special access, don't I?
You have an employer-employee relationship. I don't know that you have special access to them, because I think special access comes from that relationship ahead of time. You don't have special access just by virtue of the fact that someone walks into your house and may start cleaning. If there were an assault in that case, that would be a sexual assault. That would not be a sexual assault by one in a position of trust. The position of trust comes by virtue of the fact that this was a family friend that the family trusted. And I would disagree factually with something that defense counsel said. I don't think that this idea of this healthy, normal relationship was the main theme at trial. I mean, the testimony was about the number of years that they'd known this man, the fact that their younger child traveled out of state with him, the amount of times and things that they did with each other. They were family friends was really the gist of the testimony, and that they trusted this man. And that's why the mom said, I wouldn't have let her go work just anywhere. But since it was him, and I trusted him, we decided it was okay. And it's irrelevant that they didn't know, that they weren't sure whether the defendant was going to be there or not. And that they didn't, I think that just lends credence to this position of trust idea. The fact that they didn't care if he was there or not, because if he wasn't there, he wasn't there. If he was there, they certainly did not think he was going to sexually assault their child. Saying that you don't care whether they're there or not, they certainly cared what happened. And it wouldn't have that's true, it would not have happened had he not been in the house. But the fact is that he was, and he was in a position of trust by virtue of his special access to the victim.
But doesn't, in addition to special access, there has to be some express or implied degree of supervision over the person?
I don't think so, Your Honor. I don't think that the language in ROGO stands for that. And I wrote down some of a quote from that case, and it says, "The General Assembly's overarching intent to target those offenders who are entrusted with special access to a child victim and who exploit that access to commit an offense against the child," the court explained, quote, "A defendant may occupy a position of trust with respect to the victim where an existing relationship or other conduct or circumstances establish that the defendant is entrusted with special access to the child victim."
But those weren't Rogo's facts. I mean, that's the problem I'm having. In Rogo, the kid went with the defendant in his car, did all sorts of stuff. Here, the only thing we have is the defendant is cleaning the house, the defendant's house. Just seems to me the facts are very different. I recognize the passage that I read before in Rogo, which I think creates the problem in this case, but the facts in Rogo certainly are very different than the facts of this case.
Except that that's not the only facts. The reason that she was in that position, the reason there was that special access is because of this family relationship with the defendant and the victim and the victim's family. And I mean, she wasn't just cleaning the house. The second time she was there, she ended up staying and having dinner with the defendant and his child. I mean, that's not something that a normal employer-employee, this is my housekeeper type relationship, that wouldn't happen in that scenario. The third time, he suggested to her that she stay and finish watching the movie, and that's what led to what happened. So this didn't happen when she was cleaning the house. She may have been there to do that, but the situation changed when she was there, and it changed because of that relationship. If it's okay, I'd like to jump to the third issue, which is this evidence of, this alleged evidence of flirtation. And it's our position that that evidence had nothing to do with whether the defendant was in a position of trust with respect to the victim. It had limited relevance, and the court acted well within its discretion to exclude it. It was overly prejudicial, and it really was only relevant to consent. And Chief Judge, I actually had in my notes that the same thing that you mentioned, which was, in my opinion, this cuts the other way. If you've got a daughter, I mean, it's a 16-year-old who's in a hot tub, in a bathing suit. Let's say you as a parent thought, well, she's being a little overly silly or flirtatious or whatever you want to say. The fact that you trust your friend, despite that, goes even more to show that he is in a position of trust. I mean, I'm not saying that it's relevant, but if there is some marginal relevance, to me, it goes the other way. It cuts the other way. It doesn't go to making the victim's father look like a liar on the stand, or that or anything like that. And I would also note that Mr. Trinidad, there's no evidence, I mean, just because all of these people were around the hot tub, there's no evidence that anyone else observed this behavior anyway. It may have been obvious to the defendant and this Mr. Trinidad, but maybe that's because the defendant and Mr. Trinidad were staring at the victim. I mean, we don't know. But there's no evidence that the dad and mom witnessed any of this behavior. So
But that's just a jury question. I mean,
that's correct.
that's not an appellate issue. I mean, if the evidence was relevant, the jury could give it whatever weight they wanted to.
And
I don't understand that argument at all. I understand your argument is not relevant. And what Judge Hawthorne said, it does seem to be kind of backwards. But once you say it is relevant, what the jury does with it is up to the jury.
Right, and I'm saying, I don't think that it is relevant, but my point was, if there is marginal relevance, I think it cuts the other way. That's really was the only point I wanted to make.
Did the
Was the
trial
oth-
judge not only make a ruling excluding this evidence on the basis of relevance, did the trial judge also make a 403 determination, or not even get there?
I don't think that it got there. If I remember correctly, I think it was nipped in the bud at relevance once the other count was dismissed by the prosecution.
Was the evidence, the flirtatious behavior evidence offered or proffered as specifically as relevant to whether or not the defendant occupied a position of trust?
It was not. It was proffered initially as consent on the part of the victim to the unlawful sexual contact charge, which was subsequently dismissed by the prosecution. And so the argument went, once that was dismissed, once that count was dismissed, it was no longer relevant because there is no consent to the position of trust count.
And it seems to me the trial court excluded the evidence on the basis of not being relevant to the position of trust issue, but would have only gone to the victim's perception of her perception of the relationship with the defendant. Is that what the trial court relied on? Am I remembering that correctly?
I believe, if I'm understanding you correctly, Your Honor, I believe the court did discuss that, and it was actually almost like the court was talking to herself, saying, I don't even know, it seems to me that this goes to more what she thought of the defendant, and then the court continued, I don't even know that has anything to do with whether the defendant is in a position of trust with respect to the victim.
I see. Okay. Thank you.
You're welcome. Unless this court has any other questions, I would ask that you affirm the defendant's conviction. Thank you.
Thank you, counsel. Mr. Fishman, you have about a minute and 17 seconds.
Thank you, Your Honor. I'm going to start with your question, Judge Hawthorne, because it points up, I think, to part of the problem here with the admission of this evidence. Prior to trial, the judge said it's not relevant because consent is no longer in the case, because count 2 has been thrown out, and it's not relevant on this theory that it goes to the victim's kind of state of mind. As the trial progresses, and if you look, I think it's page 137, could be 139 of the third day of trial, after numerous objections to the exclusion of this evidence, the court finally says, you know, I understand we're not talking about consent anymore. Things have changed. I'm struggling with this, but I'm sticking to my prior ruling. And the problem is, the basis for admission had changed fundamentally. The court never reevaluated it. It just said, I'm sticking to my guns and my ruling at the 10/28 hearing, October 28th hearing. Judge Berger, I think your observations about Rogo are correct, and this is at least the way I think about it. Remember the question before the court. Can you be in a position of trust without a specific charge of responsibility for the health and well-being of a child? And the Supreme Court said, it doesn't have to be specific. Pellman kind of hints at that. Johnson kind of says it. We don't really agree with it. You don't need that. Entrustment, special access is enough. I'm out of time. I'd ask that the court reverse. Thank you.
Thank you, counsel. The court thanks both counsel for your excellent arguments, and those arguments are going to be very helpful to the division in reaching a decision in this case. So the matter will now stand submitted to the court, and an opinion will issue in due course. Counsel are excused, and the court will stand in recess, and the bailiff may so announce. Thank you.
All rise. The court will be in recess, subject to call.